And thank you, Mr. Elderfield, for coming in. I imagine it'll be the last time you come before the PAC, because you're leaving in October, isn't that right? Sometime like that. And indeed, I'm sorry that you are leaving, because I think under your stewardship things have undoubtedly improved a great deal, and I'd like to thank you for that. Could you tell us why you are leaving?
So it's really just personal reasons that I think I mentioned the other day publicly. Last August, my wife and I were in London for the Olympic Games, and we just realized we missed London a lot, and we've been away for a long time. It's almost 6 years, because I did my Irish time, which I've enjoyed, but I was in Bermuda for 2.5 years beforehand. So I felt if I'd stayed the full term, it would be something like 7.5 years away. And so I kind of mulled it over for a while. And then at Christmas, thought about it. There was lots of lobbying that took place from family and friends in London saying, come on, you've been away too long. So I told Patrick at the beginning of the year I'd give it another year. It ended up being a bit earlier. So I'd say I've really enjoyed Ireland. Living in Dublin, I've lived in lots of cities in the world, grew up in Manhattan, and I think Dublin's a great city. I've really enjoyed living here, but I want to get back home.
You're on your third year of a 5-year contract, is that right?
That's right.
So
I'll be 3.5 years into the 5 years, Micah.
does that not, with the decision made after 3 years, does that not reflect some disappointment with the situation here? That you anticipated coming for 5 and you suddenly decided that you're going to get home after 3?
No, not disappointment with Ireland or the experience, no.
Did it have any reflection on the state of the economy, the state of the job, the state of the central bank in any way?
No.
Because you're kind of leaving us at a time when the project which you embarked upon and which you've done well on, I think, is still in its infancy to some extent and very, very fragile. Would you accept that?
I would not say fragile. I know there's unfinished business, and that's something I debated a lot about. And that's a fair one. And I know there's still big challenges ahead. A big one is the single supervisor. I mean, that's kind of a big break mark where banking supervision is going to go to the ECB. You know, does it make sense to be in there for a short amount of time? But I wouldn't say fragile. I think there's a strong platform. Numbers are there. The staff quality is there. With the powers bill that hopefully you guys will all vote on the next month or so, I think there's a strong legislative framework. We have our risk-based framework, PRISM, in terms of how we're looking at firms. And I think it's clear that, you know, an intrusive, challenging approach of supervision is embedded. So I think there's a strong foundation, I'd say.
Okay, but you are leaving us with a lot to do.
I know there's still to do. In supervision, you kind of have to do your shift, but there's always more stuff on the horizon.
Okay. Can I just dwell on the stress tests, which have been delayed, is that right?
So basically, delayed a bit, aligned with the EU framework, yeah.
Does that give any cause for alarm? They are delayed. Would it not have been better to keep to the original timetable?
I personally really don't think so. I think it makes sense to align the methodology as much as possible with what's happening in Europe, and to do it on a consistent basis. And to have to do an Irish exercise, and then immediately after having to do a SSM exercise, have to like our stress test, and then an asset quality review, and then another stress test. I just don't think that makes sense. So I was very comfortable with, you know, changing it to this more phased approach. I think we'll have a bit more experience under our belt on the mortgage arrears and the insolvency legislation. And like I say, having to do 2 exercises, I think would not be wise.
Are you happy with the results of the last stress test?
I think they were very robust. I think the conservatism level was significant. The BlackRock numbers were some 8 billion tougher than what the banks wanted. And we put some extra buffers in there on top. But we're going to, or my successor is just going to have to look again, as I mentioned to the deputy, on how all these factors are looking some 2 or 3 years on.
I think you know, I've been a bit alarmed and never been able to get to the bottom of a problem about the last stress test. There was a whistleblower in the central bank at that time, wasn't there?
There was an individual who used our individual internal speaking up policy. There was an internal audit investigation of that. That was all settled, yes.
What was the allegation by the whistleblower?
I don't think I can really go into that. You know, we've looked at that situation. There's an internal audit person looked at that. And I just don't want to do anything that compromises the individual concerned there.
Was the individual suspended?
This is like a sensitive HR matter. I really can't go and talk about individuals there.
I just say, Mr. Elderfield, I think it's important that the public is happy that the whistleblower system in the central bank is working properly.
Yes.
And as you know, some of this got kind of vaguely into the public arena, and it's got it out in bits and pieces, and it's somewhat clouded. But my understanding is the whistleblower was suspended and then taken back. Would that be correct?
Like I say, I don't think I can comment on what happened to the individual. There's like employment law and HR issues there.
Naming the individual.
I can't go there, but people will figure out who the individual is, or I think the person's name might even be out there. So
it was.
I really think I need to not go there. I don't have.
Employment of central bank.
I'm just very cautious about what I'm allowed to say about an HR matter like that, Mr. Chairman. So I can say that there was a matter that was raised. It was looked at by someone independent to the management line there. I think it was looked at very thoroughly. I don't think there was anything there. The person was actually satisfied with the report that was prepared. But I'm not going to talk about when they left, what the terms were, anything like that. That's, I think, a private matter, confidential matter, and we need to respect that person's confidentiality.
I mean, if someone within that department and who was involved in the stress testing at a high level, which I understand they were saying that the stress tests were flawed, which I understand they were saying as well. And they made this allegation. And then the way they were treated is very important. And it's important to us that the central bank, which is obviously accountable to the state, is operating a whistleblower procedure in a satisfactory way. What I find difficult about this, and I understand your reticence about the individual, is to be sure that anybody from the inside who makes statements, who have an expertise in this area, and goes through the whistleblowing process, is not A, silenced, B, dismissed or suspended for those reasons, and to make sure that the right procedures and fair procedures are put in place. And because it isn't clear, it seems to me that this episode is a bit murky. It would just help if you say to us, right, what happened was the following. They made these allegations, they were investigated, we suspend them for a period or whatever happened, and then we took them back, if that's what happened. And we would need to be sure, and I know it's a very serious issue because it's very important to the nation how these stress tests are conducted. We would need to be sure that the central bank is behaving in a way which protects the integrity of the process, not just the integrity of the central bank.
Okay. I think what I have to do is try to break it down into three components, if you like. I think the status of the individual through it and what's happened, I think that really is a matter for employment law and confidential with the individual. But let me try to reassure you on a couple of points. We have a speaking up policy. When the person raised this concern, it was treated under the speaking up policy. It was treated very seriously, I would say, very seriously. We had somebody, the internal auditor, separate from that area, look into it very thoroughly, investigate it, and actually feedback to the individual, and the individual was satisfied there. I would say that for the stress test itself, we had peer review from other regulators. We had the European Banking Authority. We had our own consultants. We had the Troika, the ECB, Commission, and the IMF. We had a lot of people looking at those numbers. And actually, the stress test results we published, I think, were pretty much the most transparent in terms of the details that we provided. So if you look at our PCAR information we provided that March, there was a lot of information there. So in terms of the integrity of the stress tests and the ability to look at them and check them and test them, I think there's a lot there, and there were lots of eyes on that.
Okay. Okay. There was some sort of independent investigation into this whistleblowing allegation, was there?
But we asked for the internal auditor to look at that. Yeah.
That's not an independent investigation, internal auditor, is it?
No, I think the internal audit was independent of the management line and the individuals who were managing that individual. Yes.
But someone in the employment of the central bank?
The internal auditor, yes.
Do you regard that as satisfactory?
Yes.
And was this person someone with an expertise in the stress test area?
Person had access to people who understood the stress testing.
But wasn't employed directly in that area?
He certainly wasn't, no.
We're not saying whether it's a he or a she.
The internal auditor is a he.
Yeah.
Yeah.
Yeah. Okay. I'll leave that there. But I'm concerned. I must say I'm concerned that these things are not necessarily satisfactory. They're done behind closed doors to such an extent that there's no way that we can be sure that these queries of this sort are not being given the proper consideration that they should be.
I think.
Just make a suggestion that when you're answering,
yes.
Could you send on a note, we'll say, to review the particular circumstances of the case within the central bank, and send us maybe a specific note as to how far you feel legally you can go, and then the type of the whistleblower charter and policy you have within the central bank, and the protection for whistleblowers. That, following on from what Deputy Ross and maybe you, that you might just.
We can happily send you the speaking up policy that we have there.
And to see how far you can go in terms of the specific circumstances.
I'm very certain that we cannot get into the individual at all. I'm positive about that. I think on whistleblowing more generally, this is one of the kind of frustrating things for the whistleblower, and I'm sure for TDs about it. So let's talk about the new law that's coming in for a second. So we've got this framework that says you can now make a protected disclosure when the legislation comes in. And we have to treat that individual in a confidential way. Unless there's an exclusion, it's necessary to reveal the person for the purposes of pursuing the investigation. Now, we're thinking through that, under what circumstances you'd make that disclose the information. The FSA, for instance, tries under all circumstances not to disclose the individual's name, but sometimes it's very hard to investigate that. That's one aspect of it. The protected disclosure is great. The new framework means there's no, you can't take employment action against the individual. They're protected, et cetera, et cetera. But we also have a duty as a regulator, I'm talking in our context, to keep the firm's information confidential. So we'll have a whistleblower present stuff to us, we can't come back to them. And I think that drives them absolutely nuts. It probably drives you nuts when you talk to the whistleblowers. But that is the nature of it. We've got to be confidential towards the firms. We've got to be confidential towards the individuals. We also have to be confidential in this context to our staff members under employment law. So there's protections for whistleblowing. You care about the policies that are in place, but when you want to get to what happened to it, unfortunately, typically it happens internal to the supervisor in terms of what actions are taken. Now, of the 42 or so whistleblowing incidents we had last year, maybe about half of them we took actions on. Half of them we find don't really have any legs, there's not enough to go on. Sometimes they go to enforcement, sometimes they go to supervisory action. So whistleblowing, we take it seriously. Internally, we take it seriously from what we get from the firms too.
Yeah, I mean, I absolutely appreciate the need for confidentiality to protect the individuals, but it would be really helpful if you could give us this, I mean, you could give us a resume. What were the allegations? I don't see why we shouldn't get that about the stress test. What were the detailed allegations? Why we shouldn't get that, considering they're obviously considered to be untrue by the central bank and they've been dismissed. Why we shouldn't hear what those were and why they was dismissed and the procedures and the outcome. I think that those are things which we should be entitled to be satisfied that they're working.
I think we didn't give the procedures, but I think we had a statement covering those other points at the time, but we can look at that and see what we've got and send it to you. I think it was a bit longer than that, but yes, yeah.
Okay. Anyway, okay, let's move on. If we get something from you that's more fulfilling. Recapitalisation, which Deputy Constant touched on. There seems to be, it's an area which is so unclear and so difficult to make any judgments on. The government here say that we don't need it, and you're saying we will need it, I think, at some stage. Where's it going to come from? Where's the money going to come from?
So I think if the banks return to profitability, before the capital is eroded through losses, then that's the principal source you would like to see. If the banks become a better investable proposition, then you would see private capital. And that's obviously happened in the case of Bank of Ireland in the past couple of years. And then I think in terms of any public support, I think the clear government position is that the use of the ESM as direct recapitalisation is the best approach. Now, there's going to be a lot of debate around that over the next 9 months or so as to exactly how much and under what circumstances. I think given the link between the banks and the sovereign finances, having that tool available for Ireland, but across Europe, is very important. And you would want to have that ESM direct recapitalisation, so you don't add to this vicious cycle between the banks and the sovereign finances.
Okay, so the first one is if the banks become profitable. It's an aspiration. I mean, I agree with you, Bank of Ireland is obviously the best prospect there. But if AIB becomes profitable, it may or may not. We're going to rely on the ESM, you think, for recapitalisation otherwise?
I wouldn't dismiss the first two entirely, because there's a timing question there, right? So you have a lot of capital in the banks now to absorb losses for the foreseeable future. You may identify in the stress test, a hypothetical loss in the future. So you've got a question about how fast do you want to deal with that? You might say, actually, I'd like to have a plan to get there in stages between now and the end of Basel III. The circumstances may well be that a private investor says, okay, that's a reasonable plan. I'll take part of that. So I wouldn't rule that out as an option. And I think you want to think very carefully about how fast you want to address these things until you know the European policy framework. And that's probably a good reason to align our stress test with the European stress test, so we can see what the European framework is going to be for direct recapitalisation.
It's putting off the evil day to some extent, though, isn't it? It's kicking the can down the road, saying, okay, we recapitalise when we have the money rather than when we need to.
I would say if you've got, I mean, you can argue it both ways, and there's pros and cons of it. You can also say, look, you want to accelerate and bring everything right now because it's kicking the can, and you want to get as much capital in your bank so they can start lending. I think that's a very plausible argument. But if you're a stressed sovereign, and the only way to do that is through borrowing, then I think you say, well, maybe that's not the best way to do it. So if I was a supervisor in the US, where I had a AAA-rated country at your back with lots of money, then you'd just say, err on the side of more injections in the short term. And your micro-prudential need for recapitalization would trump any macro-prudential concern. But if you're in a situation in the Eurozone with a stressed sovereign, you need to make your judgment about timing. So I think it's a fair point, and there's arguments both ways about the speed of it. But I think because there's this debate on ESM recapitalization, I think it makes sense to see how that emerges and work on the stress tests in parallel.
And so what are you assuming in terms of legacy debt from the ESM?
I've not been involved in the discussions. The Department of Finance deals with that. I don't know which way that's going to fall in terms of legacy debt and the levels. I just don't know how that's going to come out.
When you're making forecasts or provisioning, does it not come into that?
Not on the bank side. I mean, in terms of that's, to the extent to which there might be a debt for equity swap in the future or available for more capital. In terms of what we're doing with the banks is we're saying you've got to increase your provisions and deal with your mortgage arrears, and we're going to come stress test you shortly.
Okay. Could I ask you specifically about a couple of things? Oh yeah, fitness and probity. What procedures do you put up for appointing or allowing and giving a certificate of fitness and probity to people who are made directors of banks?
So when the fitness and probity framework came in, effectively everybody was grandfathered under the law. That's the way it worked. So any new applicants, they have to apply to us, and we call it an IQ, an individual questionnaire. Gives a lot of information to help us assess both the fitness side of the equation and the probity side of the equation. That comes into a central team, and we look through that and make a judgment. For the higher impact firms, including the banks, we'll tend to do interviews for those roles and assess the fitness and probity. We've put a flagging system in place where if somebody from one of the firms, one of the banks that required a government bailout, tried to come back into the system, a flag goes up, and then we slow the process down and say we're going to have to do an assessment of this individual and see what the history of the position was. Were they in HR, therefore no responsibility, or were they in charge of commercial lending, and therefore they've got some questions to answer.
So you say, is that for executives rather than directors you're talking about, is it?
We say that for executive and for non-executive directors. So if people want to re-enter, they have to, we're going to have an extra check in the sense of, okay, we need to look more closely and establish what was this person's role in the institution in the pre-crisis period. What extent were they responsible? How does that affect the current role they're applying to?
Right. So, and you do an interview. Do you do it yourself as a panel or what?
No, it tends to be the supervisory staff will do that. A couple of them will do that. Usually the heads of department would tend to do that. Sometimes the director.
You turned anyone down?
We've had a fair number of people who have withdrawn their applications. I think about 3% of people withdraw their applications. So
How many people is that?
93, I think.
93 people have withdrawn?
Yes, I think, if I remember correctly. Give me a second, I'll just...
But these aren't people turned down by you, are they? They're people who just withdrawn, are they? I mean, how does that...
What tends to happen is that when you start to raise issues, Deputy, they tend to just withdraw. Okay. So I think I just read it this morning. I'm pretty sure that might be 94. Yeah. But anyway, yeah. So that that's what tends to happen. You raise the questions, and people, rather than have a formal determination against them, tend to withdraw.
Okay. So you haven't actually barred anybody at any stage. You haven't said no. Ever.
We've come very close to doing it formally, and then at the last minute the person withdraws.
Said you've never refused anyone.
We've never had to get to that stage yet under the regime in the last 2 years. The person's always withdrawn before getting to that. Yeah.
Okay. And how many have you approved?
Like I say, you can work out the maths. I can't do it on the top of my head, but 3% decline rate of 94. So give me
Sure you
yeah, I'm not that good on my, can't do that in my head as well. Give me just 1 second. Yes, so approved 2,200, in 2012, approved 2,234, withdrew 93, returned as incomplete 331.
Okay. Okay.
We also did a retrospective review on the sitting incumbent directors at the covered institutions. Yeah. And basically the position is that of the bank directors, both executive and non-executive, who are in place on the night of the guarantee, sort of the reference point we often use, 71 of the 73 have now left the system.
Right. Did you have any influence in them leaving?
I want to be careful what I say here. It was without prejudice to guilt or responsibility. We said we felt there should be a refreshing of the system, and that there would be this review, and really a lot of people just decided to withdraw before the review took place.
And do you have, forgive me for this, do you have the powers to remove them if you want to? If you send a message to the bank and we said we think he should go, can you do it?
So under the Central Bank Reform Act 2010, which you guys voted on, we do have the powers to prohibit individuals who are sitting in place. So fitness and probity works both as a gatekeeper role and as an ability to remove. But you have to go through various legal checks and balances and establish your case. You have to be able to evidence that the person is failing to be fit and proper for their current role that they're in. You have to meet certain evidential tests. It has to be confirmed by the courts after a certain period of time. So you have powers. I wouldn't say it's the most straightforward process to do. I think, if you wouldn't mind a small digression about accountability for individuals for a second, that's one reflection, since I'm perhaps here for my final appearance, that I'd like to mention. I did talk about it previously. I think there is a open issue about how effective the system is, if I can call it, ourselves, the guards, the ODCE, about being able to ensure individual accountability through the enforcement and sanctions process. So we've done a lot of enforcement cases against firms. We've been very successful in that, I think, in terms of raising standards there for systems and controls lapses, for mis-selling, for overcharging. But it's a lot harder to take cases against individuals. The firms tend to settle with you quite quickly, and the individuals tend to fight you tooth and nail to the very end. Now, we've got a couple of cases from the financial crisis period where we're still taking action against individuals, that it's more protracted and drawn out. But I think a reflection that I have is that seems to be an area, white-collar crime, where the system just isn't operating very well in terms of ability to tackle that. I think it is too protracted. And the deterrent value, taking actions against firms is good, but the deterrent actually against taking actions against individuals is a lot better. One of the thoughts that I had maybe a few months ago, that I think this is something that somebody in Ireland should look at, retired judge, former Attorney General, Commission, Public Accounts Committee, if that's the right jurisdiction, is really do a kind of stock take and say, how could we tackle white-collar crime more effectively? And a few thoughts. I think you've got one question which is really about the capabilities of the different players. The guards have the resources and the capabilities, the ODCE, the central bank. What's the right split between the three of us on that? You've got, I think, some questions about powers, questioning of suspects. I think the track record is weaker on certainly than the US. I mean, the UK, I think, has had some banning and some big fines for individuals who are involved with failed banks. That's not happened here. There's not been, as far as I'm aware, the criminal prosecutions you've had in the US. So I think relatively weaker. We still have, obviously, the big court case on Anglo to come, and be careful I don't want to say anything prejudicial to that. But I think you could really have somebody do a stock take about how well are we prepared as a system, and also how good is the law. So there's things like, should there be a strict test of responsibility? Establishing individual responsibility when there's a enforcement case against a firm, that's quite a tough test the enforcement lawyers have to do that. It makes it hard for us to do that. The UK is looking at whether you should have a presumptive liability or presumptive sanctions for directors of failed banks. That might be in the Banking Standards report on Friday when it comes out. Should there be a reckless trading offence for financial services? You know, exactly how do the constitutional protections to earn a living interact with the fitness and probity regime? That was a very complicated thing in the drafting of the law, which, you know, affects the ability to take action against individuals. So I think, you know, a stock take, Law Reform Commission, wise person's report or something like that, to draw this together. So I would say that we've done a good job at enforcement against firms, but I wished we'd done more on individuals. And I think the system could do better on that.
Yeah, I take that point. I'm unclear as to how you exercise these powers, because, as you'll know, there's an extraordinary reappearance of people from time to time from banks which haven't necessarily failed, or certainly from the boards of banks which have been subsequently bailed out, or who have been involved in, people who have been involved in failed departments or failed areas of banks, and they suddenly reappear on the boards of current banks. That, I presume, is not obviously that's not a factor which bars them, but it certainly shouldn't be one that is encouraged, surely. The fact that people are popping up on the boards of banks here who have been identified with failed banking enterprises in the past is something which alarms some of us, and obviously they haven't been involved in any activity which is criminal or anything like that, but they have been involved in identifiably failed projects of a mega nature, and I wonder how they get through your fitness and probity tests.
So, like I say, if the individual was a director, senior manager of one of the banks that's required government support, we have a flagging system for that explicitly to slow the whole thing down, like I say, to catch that. Our standards for the fitness and probity, the probity side is kind of one size fits all. You've got to be proper whether you're small director, big director, if you know what I'm saying, and it's about criminal background, the rest of it. Fitness is very much relevant to the individual and the role that they play. But one thing we explicitly wrote, and we had a lot of debate around this internally, and I insisted it goes in there, is we made reference to the track record of the individual in their previous roles. Now you have to interpret that in the context. If somebody was, I'd be bad at giving a good example, but you know, what sort of a role were they in the past? How directly responsible were they to the failure? How big an institution were they compared to where they're going into now? So I'll give you kind of extreme example, but if the person was HR director, senior manager in a bank, they got into trouble and then wants to be a non-executive director on a fund, you're thinking, all right, the person was on a bank, they got into trouble, but they get through. If they were senior manager, head of commercial property lending in a bank and wants to go into a similar role in that bank, then you'd slow it down. And not going to say we've done in that type of an example, but there are cases that I'm aware of where we have said, we have problems with you because of your track record in the past. We know about you from the past, and those people have withdrawn.
Right, okay.
Yeah.
I'm thinking of, I'll go on to something else. I'm thinking specifically, I suppose, of people who've been executives in banks, and they've been identified very much with failures in those banks as executives, and who are now popping up on the boards as not, yeah, I get point out, on non-executives boards on public banks at the moment. That's something I just maybe you could flag that for your successor. Do you want me to? Yeah. Okay, could I just ask you one thing about Customs House capital?
Yeah.
And then I'll just be very brief on this, but I know, and I've had, and I'm sure lots of members of this committee have had, a lot of representations from people about Customs House capital, which involves, I think, 1,500 people. It was identified as being in trouble by the central bank, and correct me, but I think my dates are right, in 2007 with a 4 million deficit. It was very, very slow to be identified as being in really big trouble and being actually running a Ponzi scheme, and it eventually was discovered what was going on, not by the central bank, but by a company called Appian Investment, which took it over. Was that a major lapse on the part of the regulator?
I think a lot of parties missed, ourselves and others, a key problem on the client assets. That was a very frustrating experience. So there was this history from '07. When I first heard about it, it was in the spring of 2010. And kind of puts us in two ways. It's like, well, let's make sure that the client assets are okay. And we'd had, from memory, we did a review, we had a third-party review, we had 2 external auditor reviews, something of that order, and all of them said some questions of systems and controls, but the client assets are fine. It's like, all right, if the client assets are fine, then do we want to close the company down, liquidate it, or do we want to try to get this management out? If we'd have liquidated it then, we would have crystallized a loss because of all these illiquid property investments for the investors. So we debated it back and forth, and we said, well, as long as the client assets are secure, let's bring in an outside chairman, non-executive director, if I remember correctly, but let's try to sell this thing to another person. 2 problems with hindsight. One is that we were getting false positives on the client assets. We got a false positive, the third-party report we got.
What's a false positive?
In terms of, they were all saying the client assets are all there because it was a fraud.
Who was saying that too?
So we did a review. There was a third-party report that we commissioned at the time. I might have commissioned 2 if I remember correctly. And there was the old auditor and the new auditor.
The third-party report gave you a false positive as well.
So some of the reports at the margin said there's some systems and controls issues, but none of them identified that the actual client assets have been diverted.
But that's appalling, isn't it? Did you pay the third party for that report?
I'm afraid they were all paid before the thing emerged. Now, so...
Who was the third party? Could you tell me?
I can't remember. I'm not being diplomatic, but I just can't quite...
Diplomatic as well.
...remember. If I could just guess, it's one of 4, but...
Could you let us know? Sorry, could you let us know, though? Could you find out and let us know who wrote the third party
if
report?
we're allowed to do... I think well, I was going to say, we did a report. We had our risk advisors do a report on Customs capital and client assets, which we published. So we put a lot of our dirty linen into the public domain on this one, Deputy, and I'll have to check whether we can disclose that or not.
Yeah.
That was very frustrating.
Well, you have full privilege here today.
Okay, I know there's privilege, but I've also got Section 33AK and other laws that govern everything I do. So that was very frustrating because that was like a false premise for your decision making. If you'd have known at that point that there was actually a fraud going on, that frauds are very hard to get, you would have taken a different course. That was one problem with hindsight. The second problem is that we only had this nuclear option of liquidation or not liquidation. We don't have the ability to put investment firms into administration. It's like it's a gap in the law. So, what would have preferred to do is take it over, put an administrator in, clear out the management entirely, and then have the administrator run it. All we had was work with the management until we can exit them and sell the thing, and then, or liquidate it. But liquidated would have crystallized the losses for the customers. So it is a frustrating experience. Then you had all this due diligence take place during the sales process. So I think there was, off the top of my head, it's in the report, 4 or 5 counterparts came through and none of them spotted the client asset hole, and it was right just before the settlement of the deal that Appian spotted the client asset hole, that it came out. So we published lessons learned on that. I think we're quite open about it, and there's some lessons learned about how we approach these things. What I think is very important is you want to have a very low risk tolerance about handling of client assets. So we've really tightened up on that. We have a dedicated client assets team. We have a protocol for any problems with client assets. We intervened with a spreads company at the beginning of last year to make sure that everything was in proper order there. And we've done some other interventions, and we've required actually the use of third parties to get the management of the client assets out of firms. So there's some lessons for us, lessons for the auditors in the way the whole thing went through.
Fine, I'm finishing it, but there's one issue here which is important, if you don't mind. We are a Public Accounts Committee. And if I'm misinterpreting what you said, just stop me. These third parties that you relied on, which you obviously did, you commissioned a report to them to tell you about the client assets.
Yes.
They actually misinformed you.
They didn't find it, but...
well, what did you pay them?
I'm sure they were paid. I'm sure they were paid at the time.
Are you taking any action to recoup the money?
But you know, we missed it. They missed it. The auditors missed it.
But that's not good enough, to be honest. It's not good enough.
No,
you miss it, okay, you come up with your hands up. They miss it, they've been paid.
We could look to see what chance we have to recoup the cost of that. I think...
They implied specifically for that exercise, but they implied specifically, the others would be general, and we'll say
yes.
but they implied specifically for a specific purpose.
They looked at a range of issues, if I remember correctly. I can't quite look on that. They looked, but that was certainly...
Would it have been part of their terms of reference to look for the particular issue to Deputy Ross?
Certainly, all of those reviews looked at the client assets controls, but none of them found the fraud. I'm not going to make an excuse for that. I just will say one thing, that fraud is the really hard thing to find on client assets. That basically you've got all the documents appear to reconcile, but all the documents you're being provided for are false. It's very hard to actually freeze the company and go right back down to a full reconciliation on the client assets. Now, we've done that a couple of times under our new framework, but it's actually a very difficult exercise to do. Not making excuses for them or for us. And to be honest, there's a lot of firms have got into trouble on client assets in the UK and in the US. And this has been a problem area in the last couple of years.
I'm trying to finish this. This fraud was discovered, and it was discovered by Appian. Isn't that right?
At the 11th hour, they saw there was a reconciliation.
Exactly.
Yeah.
They were, because they were buying the mess that it was. The people who were commissioned by you were commissioned because this company was in turmoil, because of the problems in the company. And they were presumably specifically mandated to look for something like this. And they appear to have failed completely to have done it. They've given you what you called a false positive, which is basically everything was okay. Isn't that what that means? Surely you should be looking at the means of holding them accountable to some extent for having found this, because they were acting on your behalf and acting on behalf indirectly of the taxpayer and the customers. And certainly you should be getting the money back, if not looking at how thoroughly they did their job.
We can certainly do that. I just say this, and I know you work in financial service companies yourself. When you read the small print on all the things that auditors send you, there's so many exclusions and wriggle room clauses, if that's the technical term for it, that I wouldn't be surprised if there's plenty of that in the material that they sent us. But it's a fair point. We'll go back and have a look at it. I just wouldn't. I wouldn't want to give you the impression that that's going to be an easy thing to be able to get that money back.
That's fine. Could you just let us know what they were commissioned to do, how much they were paid, and what they found, and what's being done about it? Would that be reasonable?
We'll look into that, and as much of that as we're allowed to share, of course we will.
Thank you very much. That's fine, Chairman Lee.